Welcome to S&C's podcast series, S&C Critical Insights. I'm Samantha Hines, a partner in S&C's antitrust group. Today, we're going to discuss the impact of the FTC's final rule revising the Hart-Scott-Rodino pre-merger notification form and the accompanying instructions. We're going to talk about the key changes to the rules and what steps frequent HSR filers could be taking now to assemble and advance a number of categories of information and documents that are required by the new form. With me today to discuss this topic is Brad Smith, a special counsel in S&C's antitrust group who oversees all pre-merger notifications under the HSR Act for S&C's clients. Before we get into the rules, Brad, can you provide us with some brief background on the FTC and DOJ decision to change the HSR rules?
Sure, and thank you for the introduction, Sam. So back in June 2023, the FTC issued what's called a Notice of Proposed Rulemaking that proposed the most significant changes to the HSR form and its instructions since Congress passed the HSR Act back in 1976. More than 750 comments were submitted concerning the proposed rule. While many individual commenters supported it, most corporate and institutional clients were critical of the broad scope of the proposed new HSR form. The final rule was released a couple of weeks ago on October 10th. The FTC commissioners voted unanimously to adopt the final rule, with the two Republican commissioners submitting concurring statements describing the intense negotiations and modifications to the rulemaking that were made in order to obtain their support. The final rule does scale back some of the previously proposed changes in the proposed rule, but it still requires substantially more information and documents than the current form. As a result, the final rule will increase the burden and expense associated with all transactions reportable under the HSR Act, including those that pose no competitive concerns. And barring any judicial action challenging the rule, it will become effective in late January or early February 2025.
Thanks, Brad. That's helpful context. So let's talk about the final rule that was published on October 10th. As we've alluded to, there are some significant changes that come along with the new HSR form that apply to all transactions that are reportable underneath the HSR Act. But unlike the current HSR form, the final rule imposes different requirements for the scope of information to be provided based upon the nature of the transaction. The final rule establishes three new categories of transactions, each of which involves different reporting requirements. The first category is select 80130 transactions. These are transactions like executive compensation transactions, where the buyer is making open market purchases or acquiring voting securities or non-corporate interests from holders other than the issuer. The FTC estimates that this category of transactions will comprise about 8% of all future HSR filings. Filers in this select 80130 transaction category will be exempt from providing many of the new categories of documents and information requested in the new form. The second category are no overlap transactions, where the merging parties do not have overlapping business lines or pre-existing supply relationships. The FTC estimates that this category will comprise around 47% of future HSR filings. Filers in this no overlap transaction category will not need to provide certain categories of information, including portions of the new product overlap and supply descriptions, prior acquisitions descriptions, and ordinary course document requirements that we'll discuss next. And then the third and final category of reportable transactions are those where the parties report an overlap of at least one NAICS code, or they have an existing product overlap or supply relationship that they identify in the form. The FTC estimates that this category of transactions will comprise around 45% of future HSR filings. Filers for these types of transactions will experience most acutely the significant burdens involved in complying with the new reporting requirements. So, Brad, can you walk us through a few of the most noteworthy new requirements in the new HSR form?
Yes. Starting off, for all reportable transactions that are pursuant to a written agreement, the parties will now be required to submit not only the principal transaction agreement, but all other transaction-related documents. This will include any agreements not to compete or solicit, any exhibits, side letters, annexes, appendices, and disclosure schedules that accompany the agreements. For all transactions except those select 80130 transactions, the parties will also need to identify and explain the strategic rationale of the transaction that the officers, directors, and employees discussed or contemplated. And along with that explanation, the parties will need to submit any documents that confirm or discuss the stated rationale, as well as any documents that discuss any other contemplated rationales for the deal. Filing parties will also now be required to provide additional business information in the HSR form. For all transactions except for those select 80130 transactions, parties now will be required to briefly describe each of their principal categories of products and services. And for transactions that have horizontal relationships, the parties will need to describe how each current or planned product or service competes with that of their transaction counterparty. For transactions with vertical relationships, the parties will need to describe the purchase or sales relationships between them. The FTC advises that the parties should draft these descriptions without exchanging any competitively sensitive information with each other.
Brad, we mentioned earlier that the new HSR form requires submitting additional documents as well. Can you explain for our listeners who might be familiar with the current requirements for submitting the so-called Item 4C and 4D documents, how those requirements will change under the new rule?
Yes, definitely. The new rule broadened the scope of Item 4C documents. Under the current rule, parties only need to submit documents prepared by or for officers or directors that evaluate the proposed transaction under certain competitive angles like market shares, competitors, potential for sales growth, and expansion into new markets. Under the new rule, this requirement has been expanded to include documents prepared by or for the supervisory deal team lead, who is a person who has the primary responsibility for supervising the strategic assessment of the deal. The new rule also clarifies that drafts sent to any board member or director, even if not the full board, need to be provided as if they were a final document. The new rules also require production of all plans and reports, even those created in the ordinary course of business, prepared within 1 year of the HSR filing, that were provided to the board of directors or the CEO that analyze market shares, competition, competitors, or markets pertaining to any product or service that overlaps with the transaction counterparty. For documents provided only to the CEO and not the board, this requirement is limited to documents that are prepared annually, semi-annually, or quarterly, and doesn't apply to special reports or documents prepared at more frequent intervals.
I want to take a moment and pause on what Brad just discussed, because the impact of the broadened scope of the Item 4C documents could be pretty significant for filing parties. First, the new rule expands from whom the documents are collected. Filing parties are now need to disclose not only documents prepared by or for the officers or directors, but also those documents prepared by the non-officer or director who is responsible for the strategic assessments of the deal. Second, the new rule requires the disclosure of documents that were prepared in the ordinary course of business throughout the year prior to the transaction, potentially even before the transaction was ever being considered. The impact of those two changes is that documents and even non-transaction specific documents that were prepared in the ordinary course of business must be prepared even more carefully than they are today if they discuss competitive factors that might be relevant to a future transaction. In addition, for many companies, this new requirement could meaningfully expand the scope of documents that must be reviewed in connection with preparation of an HSR filing. And so it would be wise to start the collection process early on before the transaction is finalized to avoid any potential delays in making an HSR filing. Brad, it's true that we expect large multinational corporations with diverse business lines and private equity funds with many portfolio companies to be particularly impacted by these new requirements of the HSR form. Why is that?
Yes, that's true. The final rule requires the buyer in all categories of transactions to briefly describe its principal business operations, including those of subsidiaries and portfolio companies. For buyers that are investment companies or have many different business lines, providing this information could entail a significant effort, particularly for the very first filing being made under the new rules. but may be less burdensome for subsequent filings, so long as the buyer's business lines don't change significantly. The final rule also overhauled the reporting requirements concerning minority investors and corporate governance, which the final rule states was necessary in order to keep pace with recent developments, such as the increasingly complex corporate ownership structures, the more prominent role of private equity investors in M&A transactions, and the evolving ways in which such investors can exert influence over management decision-making. The new rules are thus intended to give the enforcement agencies information about previously unidentified limited partners and co-investors that may exert influence over the acquiring entity and may also have other investments in businesses that compete with the target business. These new requirements will increase the HSR filing burden for many entities, but the burden will land especially hard on private equity funds and other investment M&A buyers that may have dozens of portfolio companies and sub-funds in their ownership structure. To minimize the filing burden, these filers should consider putting information gathering mechanisms in place now, in preparation for their first filing once the new HSR form goes into effect.
Based on what we've discussed so far, it's clear that the new HSR form is in line with other actions we have seen out of the agencies in this pro-enforcement era. And this is only the tip of the iceberg of what those new HSR form requirements are. Let's try to quantify the increased burden. How much longer will the new HSR filing process take for filing parties?
Well, it will depend on the category of transaction, but for all categories, it's clear that the HSR process is going to become much more burdensome. The FTC estimates that the select 80130 transactions will require an additional 10 hours to complete, and overlap filing transactions will require an additional 121 hours to complete. We believe the actual time required for some filers to complete a submission will likely be much higher, particularly for large multinationals with diverse business lines and private equity funds with many portfolio companies. As a result, the standard requirement to file HSR within 10 business days of transaction signing will no longer be feasible without substantial work by the merging parties and their counsel during the pre-signing phase. But the effects of the new form will become clearer as the new HSR filings are submitted during the course of 2025.
Thanks, Brad. And thank you to our listeners for tuning into this episode of S&C Critical Insights. You can find additional information on the impact of the new HSR rules in our recent memo, New HSR Form Imposes Substantial Additional Burdens on Filing Parties, dated October 25th, and available on the Insights page at www.zolcrom.com. For more information about our practice, please also visit us on the web at www.zolcrom.com.